Good afternoon, family. Today we are going through the last day of court proceedings. Judge Fabricius had told my daughter that he's putting her on the stand on this day, and we were fortunate to have our brilliant lawyer with us who had prepared everything. He had done the thinking and he had done the papers. So for the first time I had a bit of a break, and the judge asked my daughter if she's still representing herself, and she said yes. And then he put her on the stand. At this point, my lawyer said to me, "Your daughter is on the stand. Go and sit next to her and support her." This made me very happy. I stood up and I went to sit next to her. But this confused the judge a bit. He didn't know who I am. If you remember, he had asked my daughter, "Where is your mother?" And my daughter said, "I don't know." He said, "How can you know where your mother is?" So he didn't know who I am, because my daughter had told the judge that she's not allowed to know where I am because of the dangers we are in. And then she sort of intimated the things that we go through, but they were also in the papers. Then the judge asked her if she's still representing herself, and she said yes. And then he not read her rights, but like told her how the process was going to go. But the judge came with a killer move today that Standard Bank did not anticipate. The judge said, "I've actually just ordered the transcript from Justice Foury's court proceedings in December 2016. Because really everything we were talking about that day was based on that court hearing. Standard Bank had lied and said my daughter acknowledged that she signed the installment agreement, and then my daughter had promised the court that she's going to look after a car. So to get the rule nisi, they were relying on those two lies. So the judge said, "I cannot in my conscience grant confirm the rule nisi if I don't have the transcript and I see for myself that Ms. Hammond did make those two utterances." So he then said, "I ordered the transcript this morning. I've also requested them to first give us an audio tape so that my registrar can listen to it and tell me what Ms. Hammond said. In the meantime, they'll be busy transcribing." Okay, so we all sat there and he started asking my daughter questions. My daughter answered all the questions. He said, "I have never said I know anything about the car. If anything, I've told Standard Bank, the judge, and anybody who has cared to ask me, I have told them exactly the truth, that I've never spoken to Standard Bank. This is not my car. I know nothing about the car. I don't have money to buy a car of this magnitude. So for that reason, I've always said that." When Judge Foury said to me, "I want you to look after the car," my daughter stood up and said, "I cannot take that responsibility. It is not my car. It is not even my house. So I cannot take the responsibility of looking after the car." So Justice Fabricius said, "I want to see this in the transcript so that I know who is lying." Asked my daughter a few questions and then went back to the day of the attack. He said, "Please tell me what happened that day." So my daughter went on describing what happened that day. And when she started, she explained that she didn't know what was happening. She just came, she found the gate open, and when she got to inside the house, some men just grabbed her. And she said her biggest shock was when she came to the living rooms. she found me lying on my stomach with my arms tied at the back onto my feet. So I was lying there like a frog, and there were AK-47s in my head. And so, we had never spoken about this. I didn't even know what she saw. So she says, that is how I found my mother. And that's not how any child should ever see her mother. And then she started getting very emotional. And the judge said, okay, we stop. We stopped talking about this, let's talk about other things, and started asking her questions. She stood her ground. She discussed exactly what she discussed with Standard Bank during the proceedings of Justice Fourie. Then the judge gave Standard Bank the chance to cross-examine her. Standard Bank, before giving Standard Bank a chance, he had reminded my daughter that he has to give the findings of the court proceedings that day to the DPP, who is the Director of Public Prosecutions, because there'll be two counts of fraud committed. There'll be a contempt of court, and there'll be perjury if my daughter is lying. So my daughter says she knows this. So when Standard Bank comes, they start with that the DPP is coming for the two perjuries, for the perjury and the contempt of court. And on top of that, you're going to lose your career. Don't lose your career for a car. Tell the court the truth. And my daughter says, that's all I'm going to do today, is to tell the truth. That's what I always tell. Then started questioning her. And at some point, Standard Bank came with a point that we discussed in a non-prejudice meeting. And my daughter said, I'm not obliged to answer that. I said, why? He said, because you are quoting something from a non-prejudice meeting. The judge said, Standard Bank, what you've just said now, did it come from a non-prejudice meeting? Yeah, my lord, yeah. And he said, cut it out. So this went on until Standard Bank finished. Before Standard Bank finished, the judge said, I have just received a message. My registrar tells me that she has listened to the audio tape, and Miss Hammond did say she signed the installment sale agreement. And Miss Hammond did say she'll look after the car. It sounds like she did say this. So at this point, I stood up. I traveled with my files. I stood up. I went to the file. I didn't want to disrespect the judge when he told us that he's ordered the transcript. I could have told him that I have it. I didn't tell him that. But if anybody says something that is not true, then I'll produce my transcript. So I stood up and I went to my files. I took the transcript file. I opened it. The judge is looking at me. I pulled the transcript. I took it to the judge. He said, what is that? I said, it's a transcript. He said, you have a transcript? I said, yes. Why? I said, because I've learned that Standard Bank denies everything. So for that reason, after every proceeding, I order the transcript so that when they deny, I can show them the truth. The judge said, bring it here. He said, give me time to read the transcript. The judge read the transcript. He was reading very fast. And then he went, there. The child has been consistent the entire time. She told Justice Fourie exactly what she told me today. This is her mother's car. She's got nothing to do with the car. She doesn't have capacity to look after it. She's never discussed anything regarding the car with anybody. And she's not going to take responsibility for the car. It is her mother's responsibility. Now I have to pause to highlight my realization. In this 4-year battle, Standard Bank has only gotten an order against me twice. Both times in my absence. Both times through unethical conduct. Both times through blatantly lying to the judge. What saddens me here is that the system allows such glitches, where Goliaths trample on the rights of little Davids with impunity. Summary judgment was wrongfully granted behind my back, whilst I was left waiting to be heard in court. Granting Rule Nisi was the worst abuse of power, as the judge was intentionally misled. Again, this was the same conduct Standard Bank was trying to slip on this day's proceedings. But fortunately, Judge Fabricius insisted on checking the facts. Judge Fabricius said, Standard Bank, I cannot make the Rule Nisi binding. I cannot give you the order. There was silence in court. And then he said, regarding the whereabouts of the car, I'm satisfied that Ms. Hammond has nothing to do with it. She's been consistent throughout. He said, I also read that for the last 3 years, the mother has been trying to be enjoined. Then at some point, mid-sentence, he just stopped. And during all this time, he looks at both of us during all this time, and he was a bit confused. So mid-sentence, he just said, Miss Hammond, where is your mother? Please tell me the truth, where is your mother? No, he said, how old is your mother? Because I know I don't look my age, so the judge was a bit confused. He couldn't place me as her mother. Then I stood up and introduced myself. And he said, you came. I said, yes, my lord. My daughter told me that you asked after me, so I came to honor your request. He said, fantastic. He said, Standard Bank, Dr. Mngadi is here. Is she under oath? And they said, no. He said, what I've read is that for 3 years she's been trying to be enjoined to the proceedings, and you are refusing. Why is that? Can I join her today? Can I make an order now and join her to the proceedings? They said no. They were adamant. He asked a few questions a few times in a different way, and they said no. And he said, explain to me, what prejudice would it place to the bank to enjoin the owner of the car to the proceedings? He says Miss Hammond doesn't know where the car is. From the day of that violent attack at their home, she left the home to be safe in a hidden place. She doesn't know where the car is. The person who knows where the car is sitting amongst us. Why don't we enjoin her and ask her where the car is? They said no. I remember Judge Fabricius said, why not? He says, this case may be easily solvable if one just addresses everything to the crux of the case and gets on with it. He said, I'm not going to appoint myself as case manager in the agent court either, but I need to know what prejudice would Standard Bank suffer if we enjoin Dr. Mngadi today. He said, take instructions. The senior counsel went to take instructions. There was no chance they could say no, unless they didn't want to know where the car is. He came back and he said, okay, my client says we can enjoin her. Then he said, okay, now we adjourn. I'm going to go and have tea, and I need to see you at my chambers, both parties, after this. After the tea, we went to chambers. He said, I need both of you to go and draft orders and then bring them to me for my signature. And this case has to move forward. We went. Standard Bank went to do their order. Our lawyer went to do his order. We came back to chambers. The judge took their order, read it, and said, I don't want this. He took our lawyer's order, read it, signed it, and he said, that is the order for today. No rule nisi, no contempt of court, no perjury. I was enjoined officially. I was part of the court proceedings. Auf Deutsch sagen wir es fertig. It was finished. Standard Bank did not have another opportunity to bully my child. If you remember, before, during, and after every hearing, I used to write to Standard Bank and beg them for a round table so that we can solve this amicably. On this occasion, that was over. I wrote a letter of demand. I calculated every cent that I had paid to the bank. I took the original price of the vehicle and I sent 2 demands. I said, 1, I need the fraud investigated. I don't want to hear anything about dealerships. I want to know inside the bank who bypassed bank system, because that carries a lot of other connotations. It's not only fraud. Who bypassed? You see, the banks are linked to the government institutions. That's why when you go to the bank and you give them your ID number, your picture comes up. That's why you can go to the bank and apply for your ID. It is the same as the NATIS registration certificate. That is the ID of the car. There is no way you can load a wrong engine number, a wrong VIN number, and a wrong year of registration to the bank system and the bank accepts it. You have to physically use your ID code to bypass it. In the letter of demand, I said investigation, because that person has to come out. And I said, here's the final figure for the car. We settle this and we move on. But the reason the person to date has never been brought forward, do you know what the reason is? Because that person will come down with half of top management all the way to Kokstad. That's why until today we don't know yet who bypassed a bank system to allow a fraud to go through. We still need to know that. So it's of moment to note that everything I've discussed thus far has been fully ventilated, adjudicated in court, and ruled on. It is public knowledge. Importantly, it is of utmost public interest. I've received endless requests for the judgments. I've never bothered to check if any part of this matter was reported. I just had no interest in that. I have my own papers. But the public can note that not all judgments get reported. The court decides what judgments are reportable. So that is for you to conduct the homework and find the judgments. I will return to this matter when the correct time comes. What is available, however, is the court papers, which are somehow understood from the law library that no one can find. So I leave it to you to go and find the papers. I have mine. The teaching moment here is that we are obsessed with the destination. So before you even understand the veracity of the matter, everyone wants to know, did you win or lose? I think you remember I told you, it is not about win or lose. By virtue of going to court, in my humble opinion, you have already lost. That's why in my practice, I only only use non-adversarial approach. I mediate cases. I don't go to court. I only go to court if I'm dragged to court. Another thing is, for me, what is most important, other than the destination, is the journey itself. I learned a lot through this experience. I was forced to read beyond. So the journey of this experience have taught me more than anything else. So I'm very grateful to the journey, and I will make sure that I use my findings to the benefit of my people. A lot of people have also asked, what academic papers have I published? I think I've touched on this in my past videos. I don't do that. I don't write for first-class journals. I write lived research findings. I conduct lived research. I look at what my people need on the ground, and I research what solutions I can bring to the ground. That's what I document as a business plan, and then I implement it. So I'm not interested in journal articles. That's not me. There's nothing wrong with journal articles, and maybe it suits some people. That is not me. Unfortunately, in academia, especially in South Africa, it happens worldwide though, you are paced according to the papers you publish. Then you get different levels of professorships according to your publications. So I refuse to be dictated to by white supremacy on how I conduct my career. I don't want to write for journals. So how can my career depend on that? Abroad, however, they are more open-minded. So when it comes to your time to be promoted or for whatever reason, you can motivate what you do with your time instead of publishing. So the lived research that I conduct, for me, it's actually superior to anything else because it helps my people in real time. So I produce that because that's my academic work. What I have done then with this case is I've documented it and made it an academic case study, which I will run moot courts wherever people are interested. I will approach universities locally and run a moot court for law students to play with the facts and let's see what they come up with. Because it's a matter of public interest, I don't want it to die. So I'm going to keep it in the academic circles. Abroad, they've already adopted it as a case study. So I will approach local universities, but I have written a solid case study on this case. Then comes the matter of settlement. I wasn't going to discuss settlement, but I've been getting a lot of requests to discuss the settlement because apparently Standard Bank shuts the door and say this is settled. No, I will come back to that in the next video. So back to the settlement. Let me first say this was not a win or lose for me. This was a desperate fight of a black widowed mother to free her daughter from the devil's claws. Secondly, it was about a teaching moment to teach Goliath that I don't get bullied. They will never touch my car. And I achieved both. That said, the journey for me was more educational than the win. So in my next communication, it wasn't that asking for a round table to settle amicably. It wasn't that. I sent a proper letter of demand. So this letter of demand They immediately said, yeah, we're doing it. And then what wasted time was the up and down, because there were clauses that they fought so hard not to have in the settlement agreement. So obviously the first thing they're going to take out is the investigation of fraud. And because I wanted the car settled, I let that slide. Then they insisted on a clause that says, look, we acknowledge that you want to pay all the money you owe. Oh, just to reverse a bit. So during this settlement moment, remember that phone call that always offers me the latest model? This phone call came and they offered me the car. And I told them, I don't get fed by white supremacy. I earn my keep. And in law, there's something called unjustified enrichment. I don't want to have anything that I didn't work for and earn fully. So that's why I said I calculated every cent that I've paid. I calculated the cost of the car, and I offered them the difference as my settlement. So they accepted this, but they were insisting on a clause that says, I will never sue Standard Bank for anything, not their employees, not their cats, not their flower pots outside, nothing. I will never look at Standard Bank. I thought, I don't take instructions from you. I said to them, I will not sue you for anything else except fraud and gross negligence. So we fought on that for a long time. What gross negligence? What fraud? I said, if I don't have that in the settlement agreement, there's no settlement. I pay you every cent that is outstanding in my car, cash, and then I want whatever you want. I won't sue you for anything else except fraud and gross negligence. And we signed on that. I won't sue them for anything else except for fraud and gross negligence. So that's where the settlement ended. Paid them their money, they transferred the car back to us, and that was the end. My learnings from this experience. Only two. One, we, the poor, uneducated, hungry people, do not have access to the law. We do not have protection from Goliaths. Two, the value of knowledge. That's all I want to talk about today. That's what I learned from this experience. So let's start to access to law. The Goliaths, they understand the legal system so well, they invest in it. Their annual budget for litigation can educate the entire country. When they litigate against you, they will never let you see the trial. They will trap you in the periphery. You will never see the trial. Because if I had access to the trial, I would have tested the installment sale agreement. I would have subpoenaed the SAPS forensic laboratory. I would have called forensic experts. I would have called legislators. And we tested. And I would have proven that it is a forgery. But without a trial, judges are limited to solve only the question before them that day in court. So what they do is they don't allow you to get to trial. They want to hit and run quickly. They take you there. They take you to default judgment. If you try and they do summary judgment. The day they do summary judgment, the writ of execution is issued, and at that time the truck is outside your house. Do you know where that car is going to spend the night? At the same dealership. And that dealership is going to buy that car at the fraction of the price you bought it. Who's going to pay the difference? You. The bank is going to sit on your throat and they'll say, look, the car was 10 Rand, we sold the car for 3 Rand, we still need 7 Rands and you are responsible for it. So now you are paying for a car you don't have. And the dealership is doing a brand new transaction with the car. And they roll it a few times. So if I cannot prove this legally, how else can I do it? If they just go hit and run and they're out. So if you think you're going to fight back and do what I did, for 4 years, I was in court all the time, but I never saw the trial. They trap you in urgent interlocutory things. You just go like this. You'll never see the trial. Even if the trial were to come, the trial date is 5 years away. So you have to wait 5 years. I told you about the lawyers. They're all briefed. Wherever you go, they'll tell you, it's a conflict of interest. We can't do it. When you find a lawyer with a brain, you know what they do? They give him a killer retainer and they drop you. You'll never fight against them. Even if you were to find a lawyer, an ethical lawyer, do you have the money? Do you know the Justice for matter was in court for 3 days? Do you know what a senior counsel costs per day just to appear in court? It's between 80,000 and 150,000. If he's there for 3 days, it's 240,000 to 450,000, not negotiable. So they take senior counsels to court. You have to match them. 240,000, where are you going to get that from? It's not even worth 240,000. So your home is not worth 240,000. How are you going to pay that for legal fees? For one appearance, it's not even the case. One appearance. And that money does not even consider preparation, drafting, none of that. Only appearance. Where are you going to get that from? So by virtue of not being able to access the law, we need to question the constitutional promise that says everyone is equal everyone is equal before the law. How? How can I be equal to somebody I'm not standing in the same platform with? I have no access to the law. So how can I be equal in front of the law? It's not possible. We need to question that constitutional promise and a whole lot of other things that are promised in the Constitution. Things like, free market, you can go and buy a house. With what? With what? We need to look at this. Then I want to talk about the value of knowledge. I didn't come to you for any other reason except to ask you to stand up, to open your eyes, and for us to start doing things for ourselves. You see, everyone is screaming about qualifications now. That's just noise. That's just information. Education does not happen in university. University just collect these useless papers. That's not where the education happens. You know, there's the first 1,000 days of a child. That's about 2.6 years or 2.7 years. If you miss those 1,000 days, something just closes. You'll never rescue that child again. So the most important thing we need to do is to make sure that the first 1,000 days are properly covered. There's a huge jump between the first 1,000 days to university. We will look at all of that, but we need to do things properly. So what I want to do from tomorrow is I want to start talking about the educational program. I'm going to explain how the entire program works, and if we agree, we're going to come together and we're going to start doing it for ourselves. Educating our children, looking after our elders. We build old age homes. We go fetch our grannies from the leaking shacks and we put them in a safe place. We get nurses, we get caregivers to look after them, and then we educate our children. We can do it ourselves. We don't need anybody. So tomorrow I am delivering the first education video, and then we take it from there.